Welcome to another deep dive. Today we'll be taking a look at South African law.
Fascinating area.
Yeah, it's a system where many different legal systems kind of operate at the same time. We've got a stack of academic writings, legal texts, historical analogies, your sources, basically, and we'll be going through them all.
Sounds complex.
Definitely. But that's why we're here, to try to break it down and understand how it all works.
Well, to start with, South Africa is incredibly diverse.
Right.
So many cultures, languages, and, yes, legal traditions.
So that leads to what experts call legal pluralism.
Exactly. That's the fancy term for this coexistence of different legal systems.
And we're not just talking about little differences. We're talking about completely different ways of thinking about law and justice, right?
Absolutely. You've got Roman Dutch law, the basis of the Western legal system, alongside African customary law.
Two very different approaches.
Oh, absolutely. And it doesn't stop there. You've got Islamic law, Hindu law, Jewish law, all influencing the legal landscape. It's a real melting pot.
Wow, that's a lot to unpack. So how do these systems all work together? Or maybe the better first is, do they even work together?
Well, that's what this document is all about, guiding us through that very question. It's not just about acknowledging that these different systems exist.
Right.
It's about understanding how they interact, how they sometimes clash, and how they ultimately shape people's lives.
Yeah. The document talks about South Africa's kind of difficult history, right? How the current system came to be.
Definitely. It takes us back to the colonial era, when Roman Dutch law was imposed
Oh, yeah.
and sort of pushed the existing indigenous legal systems to the side.
But they didn't disappear completely, right?
No, they didn't. And that's really important to remember. They found ways to survive, to adapt, to exist alongside this new dominant legal order.
And that resilience is something we'll see throughout this deep dive. The document highlights that, especially with African customary law,
Absolutely.
it's evolved over time, but it's also managed to hold on to its core values and principles.
That's what makes it so fascinating to study.
Okay, so to really understand legal pluralism in South Africa,
Mm-hmm.
we need to understand customary law.
You're absolutely right. And your document does a great job of breaking it all down for us.
Great.
Taking it through, its key characteristics, how it approaches family matters, property rights, succession, inheritance, even the role of traditional leaders. It's a lot to cover, but it's all connected.
Right. So starting with the basics.
Sure.
What makes customary law so different from the Western legal system? What are the big differences?
Well, one key difference that a document highlights is the emphasis on duties and responsibilities
Okay.
rather than individual rights. It's a much more collectivist approach, prioritizing the community over the individual.
So like the well-being of the group is more important than the rights of any single person.
In essence, yes. And this influences pretty much every aspect of customary law, from how disputes are settled to how property is owned.
Okay, yeah. I can already see how that could lead to some clashes with the Western system where individual rights are so central.
Exactly. And that's something we'll definitely be exploring more as we go.
Okay, sounds good. So the document also talks about family life in customary law, right?
It does.
And how marriage in particular can be very different.
Yeah, absolutely. It brings up the practice of polygynous marriages where a man can have multiple wives.
Oh, right. I can see how that raises all sorts of legal issues, like what about the status of each wife, their rights, the rights of their children?
All very complex issues. And then there's the division of property and inheritance. It gets pretty complicated.
Yeah, and I bet that also leads to some tensions, right, between these customary practices and modern ideas about gender equality.
You're right. The document doesn't shy away from those tensions. It asks us to look at the challenges, the controversies, and, how these issues play out in a changing South Africa.
Okay, so it's not just about understanding the rules, but also the impact they have on people's lives.
Absolutely. Law is never just a set of rules.
Right.
It reflects society's values, beliefs, its power dynamics.
Okay, this is getting really interesting. So we've got this foundation of legal pluralism with customary law as this major driving force, I guess you could say. What else does the document want us to focus on? What's next?
Well, it puts a lot of emphasis on traditional leaders
Okay.
and the role they play, specifically their courts and how they resolve disputes.
So they operate within customary law, right? But they also interact with the official legal system.
Exactly. And that's where things get really interesting.
So is there like a parallel system of justice?
In a way, yes. But it's not completely separate. The document points out that traditional leaders are actually considered organs of state.
Whoa, wait, so they're traditional authorities.
Right.
but they're also part of the government structures.
In a way, yes. And that leads to all sorts of questions about, which court has jurisdiction, how judgments are enforced, the potential for conflict between customary law and the common law system.
Okay, this legal system is way more complicated than I ever imagined.
It is a complex system for sure, but that's part of what makes it so fascinating. It's always changing, always adapting to new social, political, and economic realities. It's a living, breathing system.
So we've talked about legal pluralism. We've touched on some of the big differences between customary law and the Western legal system.
Yes.
What's next? Where do we go from here?
Well, the document suggests we look at the other legal traditions that make up this diverse landscape.
Okay.
Hindu personal law, Jewish personal law, Muslim personal law, each one brings its own set of rules and principles to the table.
Okay, yeah, I'm curious about that, especially how they navigate this whole legal pluralism thing. We've already seen how customary law can clash with the Western system, so I imagine things get even more complex with these other traditions thrown into the mix.
You're right. It's a recipe for some fascinating legal situations, that's for sure. We're going to see some interesting compromises, some head-on collisions, and a lot of ongoing debate about how to balance these different perspectives.
All right, bring on the debates. I'm ready to dive in.
Let's do it. All right. So moving on to some other personal laws in South Africa, the document brings up Hindu personal law, Jewish personal law, and Muslim personal law as key players in this legal pluralism landscape.
Okay, yeah, this is where it gets even more interesting, right? I mean, we've already seen how customary law and the Western legal system, sometimes clash.
Exactly.
So I'm really curious to see how these other legal traditions fit into the mix. Like, how do they all interact?
Right. Well, the document points out that Hindu personal law, while influential within the Indian community, isn't actually officially recognized by South African law. Which is interesting, right? Because it creates a whole set of challenges for individuals who are, trying to navigate things like marriage, divorce, inheritance.
So how does that even work in practice? I mean, do Hindu communities have, like, their own separate courts or something?
Well, the document suggests that without that formal recognition, they often rely on more informal mechanisms, or they might end up turning to the mainstream legal system, which, might not always be equipped to deal with all the nuances of Hindu personal law.
Yeah, that makes sense. Are there any examples in the source material that show how that plays out, like, in real-life situations?
Yeah, actually, the historical analysis you gave me mentions a few cases where applying South African law actually ended up contradicting Hindu customs and beliefs.
Oh, wow.
Especially in matters of inheritance and family property.
So it's like they're caught between, adhering to their religious and cultural norms and then also navigating the legal system of the country they live in.
Exactly. It's a tough situation to be in. And it kind of highlights this tension between different sources of authority and, different ways of understanding what justice means.
Right, right. Okay, so what about Jewish personal law? I think the document all will refer to it as halacha.
Yes, exactly.
So how does that work in South Africa?
Well, the document explains that it operates mainly through the Beth Din, which is a Jewish ecclesiastical court.
Okay, remind me what an ecclesiastical court is again.
Yeah, it's essentially a religious court that has the authority to decide on matters within a specific faith community. So in this case, the Beth Din would deal with things like marriage, divorce, maybe some business disputes within the Jewish community.
Okay, so is it completely separate from the South African legal system?
Well, not entirely. That's what's so interesting. The document actually points out that South African courts have sometimes recognized the Beth Din's jurisdiction.
Really?
Yeah, it's like this kind of hybrid system where you've got the religious court operating with at least some acknowledgement from the mainstream legal framework.
Wow, that's a great example of how how legal pluralism can actually work in practice. It's not always about complete separation.
Right.
Sometimes there's this, blending and accommodation of different legal traditions.
Exactly. And that brings us to Muslim personal law, which the document says is in, how do I put it, a very dynamic phase right now. There's this big push for official recognition, especially when it comes to marriage and inheritance.
So they're not just trying to work within the existing laws. They're actually trying to shape the legal landscape itself.
Exactly. And it's understandable, right? Because a Muslim personal law, which is derived from Islamic jurisprudence, it often differs quite a bit from South African law.
Right.
Especially in areas like polygamy or the rules around inheritance.
Yeah, I can see how that would lead to some pretty heated debate. Is the document, is it neutral on this whole issue of recognizing Muslim personal law?
Yes, yeah, it lays out the arguments for and against recognition in a pretty balanced way.
Okay, good.
You know, the people who support recognition, they argue that it's essential for protecting Muslim couples and families, for ensuring their equality under the law. But then the people who oppose it, they often worry about, conflicts with the Constitution.
Right.
And with existing laws, especially when it comes to things like gender equality and, the ban on polygamy.
So it's a tough issue, right? Like, how do you balance those different values and principles? Sounds like South Africa's still figuring that out.
It is. And, that struggle to find that balance, it's not just limited to Muslim personal law. It comes up in the evolution of customary law, too.
Oh, right.
We were talking earlier about how customary law is always adopting.
Yeah.
The document specifically mentions the Recognition of Customary Marriages Act as a prime example of that process.
Okay, could you remind me what that act was all about and why it was so important?
Sure. So before the act, the legal status of customary marriages was, a bit unclear.
Okay.
It led to a lot of confusion, sometimes even injustice, So the goal was to formally recognize these marriages, to give them legal protection, to bring them into the mainstream legal system.
So it was about bringing more clarity and, legal certainty to those who were mated under customary law. But did it solve all the problems? Did it resolve all the complexities?
Well, not really. It did recognize polygynous marriages, but it also tried to balance traditional practices with modern ideas about gender equality. And that's where things get tricky.
Right, because you're trying to bridge two very different worldviews.
Exactly. And sometimes that creates new legal challenges, especially in matters of, property and inheritance.
Yeah, that makes sense. Are there any cases that illustrate that, those challenges?
Yeah, one of the legal texts we have actually goes into a case where a woman who was married under customary law, she challenged how her husband's estate was being distributed after he died. Her argument was that the traditional rules, which, favored male heirs, were discriminatory and violated her constitutional rights.
Wow, so this isn't just an academic debate.
Right.
It has real-world consequences for people who are caught in between these different legal systems.
It absolutely does. And the document highlights how these types of cases force the courts to really grapple with some fundamental questions about legal pluralism. Like, how do you reconcile cultural practices with modern ideas of justice?
Right, right. That's a tough one. It's like trying to fit a square peg into a round hole sometimes. But speaking of tricky situations, we were talking earlier about traditional leaders and their courts. The document seemed to imply that they play this this unique and sometimes controversial role in the South African legal system.
Yeah, for sure. It's important to remember that traditional leaders, even though they're rooted in customary law, are also considered, organs of state.
Right, right. We talked about that earlier.
So they have this official role in dispute resolution, operating, kind of alongside the formal court system.
But their courts are pretty different from, conventional courts, right?
Oh, yeah, definitely. The document emphasizes that traditional courts often focus more on mediation and reconciliation. The goal is to restore harmony within the community rather than, just punish wrongdoers.
So it's less about assigning blame and more about finding a way for everyone to move forward.
Yeah, exactly. And it's usually less formal, too, relying on customary procedures and, a lot of emphasis on consensus building.
It sounds like a very different approach to justice. Like it's more about healing relationships than it is about, punishment.
You could say that, yeah. But of course, it's not without its critics. Some people argue that traditional courts lack certain safeguards that would ensure fairness, especially in cases involving, say, women or people who don't, fully adhere to customary norms.
So there's this ongoing debate about, the legitimacy of traditional courts within the South African legal system.
Definitely. And the document kind of encourages us to think about those complexities. It's not about, saying they're good or bad. It's about understanding both their strengths and their weaknesses and how they fit into this, this pluralistic legal framework.
Wow. I'm starting to see how legal pluralism isn't just about different sets of rules.
Right.
It's about different worldviews, different values, different ideas about what justice even means.
Exactly. And the document really pushes us to go beyond just the legal principles themselves and think about the social, the cultural, the historical forces that have shaped this landscape.
Okay, so we've talked about customary law, traditional leaders, Hindu, Jewish, and Muslim personal laws.
A lot of ground covered.
A lot of ground covered. What's next on our journey through South African law?
Well, the document wants us to look closer at customary crimes and delicts. This is where it gets even more interesting,
Okay.
especially when we consider how customary law approaches things like intent, causation, and the very purpose of punishment.
Yeah, we talked earlier about how customary law often prioritizes, community harmony
Right.
and restorative justice over, individual rights and punishment. So I'm curious to see how that plays out when it comes to actual criminal offenses.
It's a fascinating area, for sure. Get ready to encounter concepts like collective responsibility and a very interesting blend of punishment and reconciliation that might challenge your preconceived notions of what justice should look like.
All right, so customary crimes and delicts. This sounds kind of tricky. The document makes it clear that these aren't always, neatly defined categories like in Western law.
You got it. Something that might be a private matter in Western law could be a big no-no in customary law.
Oh, okay, interesting. So, like, what kind of things are we talking about?
Well, let's say damaging a sacred tree.
A tree.
Yeah, the document gives this example where, a sacred tree seen as a protector of a village gets damaged. In Western law, that's maybe a property issue. But in that community, it was a serious crime because it was seen as a threat to everyone.
Wow, so it's not just about the acts itself, but what it means to the community.
Exactly. The symbolic and social impact, that's what matters.
So how does that community focus affect how they see intent and causation? Like, who's responsible if something bad happens?
Well, the document talks about collective responsibility. Sometimes a whole family or clan could be held accountable even if they weren't directly involved.
Really, that seems, a bit unfair, doesn't it?
Yeah, some people criticize it, especially, compared to modern human rights ideas. But in customary law, it comes from this strong sense of group unity, like what one person does reflects on everyone.
Okay, so it's about keeping the community strong and connected. What about punishment then? Is it like Western law, focused on punishing the individual?
Not really. The document point out that customary law is often more about restoration, reconciliation. It's about fixing the harm that was done, bringing the person back into the community, and restoring balance.
So it's a much broader approach, not just focused on the offender, but on the whole community.
Right. It often involves things like compensation to the victim, apologies, rituals, things like that.
Interesting. It's almost like community therapy in a way.
Yeah, kind of. But of course, there are still serious crimes. Assault, murder, customary law recognizes those.
Right, of course.
And the consequences can be harsh. Fines, corporal punishment, even banishment in some cases.
So there's a balance then between accountability and this idea of communal healing.
Absolutely. It's not always easy, but that's the goal.
Well, this has been really eye-opening. Customary law is so different from what I'm used to.
It's complex, for sure. And remember, it's not static. It's always evolving, responding to new influences, both from within and from the broader South African context.
Right, like with the Recognition of Customary Marriages Act, trying to modernize it while still respecting its traditions.
Exactly. And that tension between tradition and change, it's everywhere in the South African legal system, not just in customary law.
Wow, this deep dive has been a journey. We've covered so much. Legal pluralism, customary law, all those other personal laws, even the role of traditional leaders.
You got it. South Africa's legal system, it's a real tapestry, woven from all these different threads of history, culture, values.
And it reminds us that law isn't just about rules on paper. It's a reflection of who we are, where we've been, and where we're going as a society.
Absolutely. And maybe the biggest takeaway is that legal pluralism, even with all its challenges, is really about figuring out how to live together, respecting each other's differences while still trying to create a fair and just world for everyone.
That's a great point to end on. So to everyone listening, we hope this deep dive has given you a glimpse into the fascinating world of South African law. Keep exploring, keep asking questions, and remember, the journey to understanding is never truly over.